So, I'm Mike. I'm here with David Ellerman. We'll be talking about the human rental contract. Do you want to tell us a little bit about your background, your experience?
Okay, I'm trained as a philosopher, economist, and worked many years on worker cooperatives and did a lot of writing on the theory behind it. And so a lot of my writings are excerpted on the website, Abolishing Human Rentals. And so this video is to sort of explain some of the ideas. So the first idea that people ask about when they sort of see the website is, why do you say human rental? What's that? That aren't people hired? And so the first concept you have to sort of explain is that the hiring of a person and renting a person are basically the same thing, that we have this sort of linguistic habit of talking about hiring people but renting cars or renting apartments. But the economic relationship is the same, that you have, you could buy a car, you can buy an apartment, or in slavery times you could buy a person, but when you rent it, you're only buying a segment of their services, renting the car for a day or buying apartment services for a month or something. And the same thing in the hiring relationship, the employment contract, you're basically renting a person or hiring a person for a fixed period of time. And it's just as you decide where to drive the car, you decide where to tell a person to work, and that's the management role of the employer, telling the employee what to do. So that's the, we use the word rental sort of to try to get people to think anew about these questions, because everybody's used to the word hiring, and it's the same word. Even in England, we talk about rental cars here, but if you go to England, they talk about hire cars, and it's the same concept, just what you're linguistically used to. So the name human rentals is trying to get people to think anew, but it's about the employment relationship, the whole relationship where you employ another person, or you hire another person, or you rent another person, and it's all the same thing where you're buying their labor services essentially as a commodity that now you own and you can command. And so the argument is there's something inherently wrong with this contract, and this perplexes people because they've been taught that the whole problem of slavery, for example, owning other people, was it was involuntary, and slavery is almost like, by definition, involuntary. So how could we make an argument that this contract was wrong when it's voluntary and the other is involuntary? And the answer to that is not that the hard labor contract is really involuntary. That's an argument some people make, but is basically nonsense. The argument is that there can be things inherently wrong with the voluntary contract, like the voluntary contract to sell oneself into slavery, which was an actual contract. And historically, very little slavery can be accounted for that, but the intellectual foundation for slavery and the more sophisticated defenses was that slavery was based on an implicit contract. So if you get 18 years of food, clothing, shelter from the master when you're born a slave, you've got to work that off. It's like working off a debt. And of course, as you continue to work it off, you continue to get food, clothing, shelter, as it were, from the master. And so it's one of these like debt peonage. So you had this like debt peonage interpretation of it being an implicit contract. And that was one method of becoming a slave. Another method of becoming a slave was you're a prisoner of war, and this is in Roman law. And you can plea bargain, because if you're a prisoner of war, then you can be killed. And it's like you committed a capital crime by fighting against Rome, and they can kill you, but you can plea bargain that into a lifetime of slavery. And so it's a nasty contract, but it's a nasty choice and so forth. And then there's an explicit contract. So in Roman law, which is the foundation of all Western jurisprudence, you had these three ways of becoming a slave: the explicit contract, plea bargaining from being a prisoner of war, becoming a slave, and then being born a slave and getting the master providing your food, clothing, shelter for 18 years in return for your services, and have to pay that off, as it were, when you become old enough to do useful work for the master. So, in the whole history of abolitionist thought, the abolitionist thought wasn't arguing against involuntary slavery. Nobody really defended involuntary slavery. The argument was, what's wrong with a voluntary slavery contract? Because that's what the sophisticated defense of slavery was. It was one of these three types of implicit or explicit contracts. So there's a whole theory about what can be wrong with a voluntary slavery contract. And those are outlawed. That was outlawed the same time that slavery was abolished after the Civil War, and is now an invalid contract, no matter how voluntary it is. And you get certain philosophers like the libertarian Robert Nozick that said, well, we should allow that contract, allow people to sell themselves, not to mention just rent themselves. So what I tried to do was to go back to that tradition and find the traditional arguments against the contract to sell oneself. And it turned out there is a whole tradition that actually addressed that and developed a theory as to what was wrong with that contract. And the theory turns out also to apply to the renting contract, and that's what made it sort of a more radical theory. So let me outline that theory, what it says. So basically the idea is you have a contract that says, I will take the legal role of a non-person, the beast of burden, say. And, or another contract like this, which I should mention, is the old style marriage contract, called the coverture marriage contract, where the woman says, I will give up my independent legal personality to become your wife, and I'll take on your last name, et cetera, et cetera. So I'll move from the cover of the father to the cover of the husband. So I'll never be a femme sole, an independent woman. I'll be the sort of a secondary creature that cannot own property or cannot sign contracts in my own name, but only as the extension of the husband. So that contract is also a voluntary contract for centuries. That's also been abolished, and now you can only get married under the sort of partnership contract. And you don't have to give up your independent legal personality. So we have two types of contracts that are pretty well known, that are both abolished, and the one that remains is this rental contract, the employment contract. So what are the arguments? Well, the argument is that if you, either one of these contracts, you have a perfectly adult, rational person making a contract to take a legal role of either a non-person or a like a person that doesn't have full capacity, like a child, or someone that cannot own property or make contracts in their own name. But you're still, the woman that got married was a perfectly adult woman, and the people that made the slavery contract were perfectly normal people. So they can actually fulfill the contract. They can actually become a thing voluntarily. They can actually become a de facto child. But the law said if you obey your master, obey your husband, or obey your master if you're a slave, then you will count that as fulfilling the contract. So it's a perfectly good contract that the master does something for you, pays you to become a slave, or the husband provides you with this or that, and then you obey your so you never actually fill the legal role. You never actually become a non-person or a diminished person, diminished capacity. But the law says you fulfill the contract, therefore we will legally enforce that. And so you cannot own property in your own name because that's what was in the contract, and you cannot be responsible for your actions because you're just a slave or whatever. So the basic theory was that the contract is like an institutional fraud. It's where you say you will voluntarily take on a legal role that you can never actually do, but the legal institutions will play along with the game and will count you as if you were a non-person, or count you as if you were a person of diminished capacity, as long as you obey the master. When you step outside and don't obey the master, then you become a person again. So when the slaves committed crimes, then no longer they were instruments, then they could be charged by the law for murder or whatever it was, and the same with women when they committed crimes. So the sort of fiction that was involved, we're going to play like you're not a person, was there all along. It was, and it turns out the same thing, all that same fiction holds in the employment contract. It's just a shorter term, where I'm not buying you lock, stock, and barrel. I'm buying so many of your services for 8 hours a day or whatever the duration is, but it's the same idea, that when you work as a employee, you don't own anything you produce. You're not liable for any of the cost of the materials that you use up. You're simply seen as a provider of this service. So you're getting like the rental fee, the wage paid to you, and you have no responsibility, as if you're an instrument. I mean, even the language says you're an employee. You're employed by the employer, as if you were an instrument being used by the employer, and the employer was acting through you to produce the product instead of you producing their product. And in fact, you never actually give up your human status. You're just as much de facto responsible for the product in both the positive and the negative, using up the various things that are the cost in an enterprise and producing the product which you sell for revenue in an enterprise. But you have none of that legal responsibility, because legally, as long as you obey the master, then you're just an employee. You're just a provider of this input to the activities of the master that then is employing your labor along with these other things to produce the product, as it were, as the fiction. And the fiction is exposed in the same way when the employee and the employer commit a crime. See, then suddenly the law says, well, there's no more we have this fiction which we're now going to throw away, and we're going to say you were two responsible people that together committed this crime, so you're partners, and we're going to charge you both for the crime. Exactly what they didn't do when there wasn't a crime committed. But in both cases, the people are the same. So the people are just as, in fact, responsible for what they do when they're not committing crimes. They don't suddenly become machines when they don't commit crimes. But the law then says, well, no crime is committed. We have a contract here. You have obeyed the master. The contract legal implications are that the master gets the ownership of the product and the master bears the liabilities, and you're just a supplier of this labor. And when the hired criminal says, well, I'm just a supplier of the labor. I got paid my wage and I can't be responsible for the murder. And the law says, oh no, you're co-responsible. You never gave up your responsibility. So it's obvious that this is a fiction that's being involved here. And yet that's the basis of our whole economic system now, is this employment contract where we employ other people as our employees, and they are paid to provide this input to the process, but they are themselves not seen as actually being responsible for anything, even though they're responsible just as much for that as they are when they commit crimes at the behest of the employer. So that's part of the argument, and so the argument is that the contract, even though I voluntarily, the hired criminal voluntarily wants to be an innocent. He doesn't want to be responsible for murder, so he's willing to voluntarily alienate that responsibility. But the judge says, how can you eliminate responsibility? I mean, you knew what you were doing. You voluntarily did it. You followed the order of the master when he said to rob the bank or do whatever it was. So this is not, human action is not like a commodity that I can transfer from one person to another. I can transfer a car can be driven by one person, driven by another person, or a house or glass can be transferred from one person to another. But your own action is inextricably your action, and anytime you perform it, knowing what you're doing, even at the behest of the employer, you're co-responsible. So this whole idea of applying the contract of rental to human activity is just a fraud. It's an institutionalized fraud, and should be, as history has already abolished the contract to sell your labor all at once, the slavery contract, as history has abolished the contract for the woman to become a subhuman person without an independent legal personality. Those have already been abolished, and yet they're perfectly voluntary contracts. So the contract to rent oneself, which is the basis for our system, should also be abolished. So it's like the new abolitionism, and that's sort of the fundamental message of the website and a lot of my writings. And it goes beyond the whole issue. We're not saying it's involuntary. We're saying you agreed to the contract, but you can't fulfill it. You can't turn yourself into an actual thing for 8 hours a day, just as a woman getting married doesn't turn herself into a diminished person. In fact, but the law says, you obeyed your husband, therefore, you're still legally married and so forth, and therefore you can't own property in your own name or sign contracts. But we abolished that now. And so basically this is a new form of abolitionism. It says that what was abolished was not just involuntary slavery. What was abolished in the 19th century was voluntary slavery as well. And at the turn of the 20th century, in most advanced countries, they also abolished the coverture marriage contract, that the woman becomes this sub-person. And today what survives, and is in fact the basis for our whole economy, is a rental employment contract, and that should be abolished as well. Now what that change would entail is that means in every enterprise, the people who work in the enterprise would not be employees, they would be the members of the enterprise. So it's like the idea of democracy applied to an economic enterprise, just as the people that live in a country or live in a municipality become the citizens, the voting citizens. So the people that work in an enterprise would not be employees of the enterprise, they would be the members of it. And so we often describe this by saying employee ownership or worker ownership, but ownership's not the right word, it's membership, because you're participating as a human being makes you responsible for the product and makes you for the cost as well, and so you should be a member of that organization that legally, of course the company itself owns the product, but you are the company because you're the members of it. And the external shareholders would then become just suppliers of capital, so they're like bondholders then, and so there's no state ownership. It's not related to socialism at all. It's a perfecting of the private property system where people finally get the fruits of their own labor, instead of being rented instruments that don't get the fruits of their own labor. And if you have any other principle for making private property more just than getting the fruits of your labor, I don't know what it is. And what is usually defended as the private property system is this idea that the employer appropriates the fruits of his labor. His labor meaning the labor he bought from the people working for him. It's not. It's as you see in the case of the hired criminal, they are still actually responsible for that, along with him if he's a working employer. If he works in the company as a manager, that he should be part of the company as well, not as an employer, but as a manager. And so that type of company is what was traditionally called a worker co-op, and that's the worker cooperatives here, T-shirt. So the argument is, number one, that there are certain voluntary contracts that should be abolished and have been abolished historically. The contract to sell yourself, the contract to turn yourself into a sub-person as a part of the marriage. And what we have today is simply the short-term version of the selling contract where you rent yourself out instead of selling yourself. And we have the special language of I hire myself out or I'm employed and so forth. And so the argument is that should be abolished. And it goes back to the very idea of private property. Is the problem is not private property, but how do you assign new property that's produced and old property that's used up? Who gets the liability for property that's used up? Who gets the ownership of the new property? And it turns out not to be the people responsible for it, who are employees. It turns out to be the employer that could be completely absent from the whole production process and absentee ownership and so forth. So it's actually at the same time you're abolishing a fraudulent contract like the old slavery contract or the marriage contract. You're also perfecting the private property system by finally getting people getting the fruits of their own labor in the company that they are the members of and own the product and are liable for the cost of the company, because that's the fruits of their labor, the positive fruits and the negative fruits of their labor. So it's very different from the traditional what the defenders of the current system like to say the only alternative is communism or some form of socialism. Not at all. In fact, the slave owners tried to defend their system in the name of private property. The slaves were their own property, and so they viewed the whole abolitionism as a violation of private property. And in fact, it improved the private property system because that finally things that should not be treated as property, people were not property anymore, so it actually made the system more just. And the system is not quite fully just because people are rented and don't get the fruits of their labor because of this fraudulent contract. So the problem is not property. The problem is property should be improved, private property, and made just by not having this whole idea that people that actually produce a product are rented, or employed, hired, and making them so they're always the members of the enterprise and are the owners of what they produce. They get the fruits of their labor. So that's the elevator version of the ideas, the short version.
What about the alienation angle?
Yeah, so the idea that when I say these contracts can't be fulfilled, then as you see, for example, from the hired criminal example, is I cannot alienate my responsible action. I mean, you can play the boss and I can play the worker, and you say, go rob the bank, and so I go rob the bank. I am always ratifying that action. I'm always accepting to do it myself. I'm not an automaton. I'm not a robot. So it becomes my action when I ratify it. So in the end, we're both responsible. And the law would say that. The law would say correctly that you cooperated together and each in your way to rob this bank. And so don't give me this I was a hired hand and I just got paid for doing this. And so where you became a partner when you cooperate in a joint human enterprise. And that's all human enterprises like that. The firm, when you're in fact an employee in a conventional firm, you're just as much co-responsible for the results, even though the law says, you sold your labor. You alienated your labor, as if somehow my labor, my responsible human action was something that I could give to somebody else the way I would give them a glass or let them drive my car or give them a hammer or something. Those are real commodities. Those can be transferred. And so you can take the hammer and do something with it, and I have no involvement in that because that's been alienated. But I can't do that with my own action. I can't say, do with me, tell me to rob a bank and I won't be involved because I alienated my labor. It doesn't get alienated. You're always inexorably co-responsible. And the law recognizes that. That's the whole basis for holding hired criminals responsible for the crimes, even though they were hired. And so in some sense, I'm ironically saying that just as we throw away the labor contract when people commit crimes together, we should do the same thing. And when people don't commit crimes together, they're still jointly doing a human activity, and they should be held responsible, positive and negative, for the results. And that's what happens in like a worker cooperative, where the people are members that work there and they own the product and they're liable for the cost, and they're the ones that make up that enterprise.
And how does this change the decision-making structures within the worker cooperative?
Well, it becomes a democratic organization, and that's actually.
So what's the fundamental myth underlying the modern corporation?
So when you give this argument about the invalidity of the employment contract and abolishing human rentals, then one argument you'll get back, almost guarantee, is, well, the employer owns the firm, and he has ownership right to all the future products, and owns the management rights and so forth. It's all part of his private property when he owns the firm. And so what we are suggesting they see as abolishing that private property right. And this, I used to, when I first started thinking about these issues, I was also caught up in this idea that somehow the rights to manage and the rights to the product are part of what you own when you own capital. And this used to, in the old days, this used to be also what was considered part of ownership of land, that the person who owned the land automatically had the right to govern, in the political sense, govern whoever lived on the land. And so what today we call the landlord was, in historical terms, the lord of the land. He ran the courts, he ran the political system, and so forth. So owning land was seen as carrying with it all these governance rights over the people. And then that idea people carry over metaphorically to capital. Said, well, if I own the machine, then I sort of own the enterprise where the machine is used with labor and so forth. And that turns out simply to be false. And it's very easy to see that it's false in the current system, because you can rent a machine. You see, so when I rent a machine from somebody else and I use it in a business, he still owns the machine, but he doesn't have management power in that business. He has the right not to rent it to me. If he doesn't like the rental, he can negotiate the rental. But he doesn't. When I use the machine in the business, he doesn't have any management right at all. Because that's so. When I rent a car, the rental car company can say, well, you can't drive here, you can't drive above this speed, or they can put constraints on it, but they can't tell me where to drive, or they don't have the discretionary control that we would associate with managing the use of this machine. So when the rental contract goes the way in which the machine is the one that's rented, not the person is rented using the machine, then they still own the machine, but they don't have those. So those rights are actually not part of the ownership of the machine. They're not part of the ownership of capital. And so the rights in the conventional firm to manage and to own the product are a result of the contracts that are made. So what in economic terms we call a contractual position, not an ownership position. So if I have, in the system as it exists now, if I rent all and buy all the inputs, and thus rent the machines and already own the machines, or buy the secondary goods that are inputs, or buy the energy and whatever. So I've owned all the what economists call the inputs into the process, including the labor. Then I bear all those costs, and then I get the claim on the product. And so it's not that the claim on the product was part of the ownership of the capital, because the building might be rented, the land might be rented, the machinery might be rented. But I was the one that paid all those costs of the rentals, if I didn't already own them, and I got the product anyway. So getting the product is not a function of owning the capital. It's a function of being the last person that pays all the cost involved in that, the rental cost of the capital, the rental cost of the land, or whatever it is, which is independent of whether I actually own the land or own the machine or the buildings. Now, when you take that machine and that land and that building and you put it in a corporation, you see, then you simply have an indirect way to own those assets. And yes, you do have owners of the corporation, but the corporation need not be the legal party undertaking the production process. Corporations lease out their buildings and lease out their land, and lease out their capital, their machinery. And it's the fact that the corporation typically hires in labor and buys the other inputs that it then gets to own the product. So the ownership that the shareholder has of the corporation isn't the ownership of the firm in the sense of the economic entity undertaking the business. It's just ownership of an asset holding bin that could be used to do business if you make the right rental contracts, or could just be used to rent it out. When I have a corporation that's in real estate business, then I rent out real estate, lease out, shopping space or something to a company. I don't run that company. I'm just one of the suppliers. Yet I own the building, you see, or I own the mall, or whatever it is. So owning that corporation that then owns the mall doesn't mean I owned all those businesses, because I lease the space to these other businesses that run in that mall. So the myth is the myth that owning the capital, the means of production, means you are automatically an employer, isn't true. Capital can be rented, land can be rented, machines can be rented, and buildings can be rented, and so forth. So it's not just human beings that can be rented in the system. And it's really this question of who ends up renting who. So what we're suggesting is not that this false property right be taken away, because the property right doesn't exist. What exists is the right to rent human beings in addition to the right to rent all these other things, and that's what allows the existing corporation to become the firm, undertake the business, by renting all the people or employing all the people that actually work in the corporation. And so it's that role, it's the contractual role that counts, not the shareholders' right to own the corporation, because even when the corporation is just an asset holding bin leasing out, then the shareholders have exactly the same rights they had before. It's just now that their business is one of leasing out capital rather than employing capital together with labor to produce a product. So that's what is the fundamental myth, this idea that somehow it's part and parcel of private property rights that I am the manager and I am the employer and I get the product as part of that. So what we are suggesting is not that property right be abolished, because that property right doesn't exist, that the right to manage. That depends on how the contracts are written. And the way in which the employer gets the legal right to govern the workers is not because he owns the factory building or owns some capital, but because he's employed them. And the building may be rented too, and the land may be rented too. And it's the rental contracts over the people and over the buildings that gives them the management rights over the enterprise. So one has to be very clear about. So what are we really saying? So we're not denying any existing private property right of the employers. We're denying them the contractual opportunity to rent other human beings. That's what we're doing. And that's already been denied them in the abolition of the slavery contract, when involuntary slavery was abolished. Also voluntary slavery was abolished. So that violates their freedom of contract. The freedom to buy other people has already been abolished. The freedom to have a marriage contract where the woman becomes a sub-person, that's been abolished. And we're also saying, if society is going to continue to improve, that you also have to abolish this freedom to contract to rent other people. That people should always be the members in whatever enterprise they do as equal members of these democratic enterprises. And so there's no abolition of private property. In fact, you're improving private property. You're abolishing the myth that they have these rights as part of their private property. And you're denying them the contractual freedom to rent other people, just as they're already denied the contractual freedom to own other people or to marry and make the partner be a sub-person. And of course, also this political contract, they're denied the right to make themselves a king by getting people to give up the right to govern themselves to them in a non-democratic constitution. So there are all sorts of contracts that are already abolished in the great abolitions of the past, and the abolition of slavery and the abolition of the old form of marriage and the abolition of monarchies in favor of political democracy. And we're suggesting that society should continue to improve by abolishing this whole notion that you can rent yourself out and become an employee in an enterprise rather than an equal member that democratically elects the board of directors or the legislature that then chooses the management. So that's the fundamental myth, and that's how it plays into these arguments that you have to get people to think beyond and say, this can't be part of the ownership of capital, because capital can be rented and then you still own the capital, but you're not managing the thing and you're not managing the business. And so the manager of the business couldn't have been part of the capital, right? Because you still own the capital. And so it's really how the rental contract is made. So we are suggesting that society should continue to be improved, and the contractual freedom, the liberty of contract to sell yourself, the liberty of contract to get married as a sub-person, and the liberty of contract to rent yourself out are all fraudulent liberties that people don't actually become sub-persons real, or don't actually become things, and don't actually become rented things in the employment contract. It's just an institutionalized fraud, and all those contracts, not just the other ones, should be abolished. And so that just as you can't give up these rights in the old form of these contracts, so in a really just society, you would not be able to rent yourself out. You would become a member in every place in which you work, and a member, which is like a worker cooperative, where you become a member of the cooperative and work in it for a certain time period.
So what are the implications for the management of the firm in a worker cooperative?
Right. Well, the idea is that the firm basically becomes a small democratic organization. And this raises the whole question about democracy in the workplace, and why in a society where everybody's talking about democracy and we're willing to have adventures all over the world to make the world safe for democracy, don't we have democracy in every firm, every organization? And that gets us back into another story about intellectual history. And once again, just as slavery was incorrectly, from the theoretical view, incorrectly sold as being inherently involuntary, when in fact you had voluntary slavery as a way that the people that tried to legitimate it argued that it was implicit contract, so we've had democracy sold as government based on the consent of the governed. And that is not of course it's based on consent of the governed, but democracy is something more, because all the non-democratic regimes throughout history that had any sophisticated defense would all say it's based on a contract where you have given up your right to govern yourself. You have alienated the right to self-governance to the monarch or to the king or the sovereign or whoever it was. And this is even there in Roman law, the lex regia of the Roman people give up their right to govern themselves to the prince. And the question was, is that delegation, or is that giving up a alienation where the prince rules in his own name, or is it a delegation where the prince rules as a representative or a delegate or a trustee for the people? And so two diametrically opposite interpretations of this contract, and all the democratic theory came out of the interpretation that this is a representative relationship, a delegation, not an alienation, whereas the sophisticated defenses of monarchy were that people alienate their rights, so that the king doesn't rule in the name of the people, he rules in his own name, and doesn't have to satisfy any representative function and so forth. So your self-governance is like a commodity that you can give up and transfer to the monarch. And that's been the sophisticated defense of non-democratic government all along. So simply to say democracy is based on the consent of the governed is wrong, because those non-democratic systems are also seen as being based on the consent of the governed, but the consent to a contract or constitution that gave up your right to govern yourself. So they weren't democratic constitutions, they were anti-democratic constitutions. Both had consent, theoretically, but the democratic theory was there's something wrong with a non-democratic constitution, a contract where you give up the right to govern yourself, so that all constitutions should be inherently democratic. Now, to make a long story short, of course, the employment contract is the non-democratic constitution for the workplace. The employer is not the representative of the employees. The employer is not the trustee or the delegate of the employees. So that contract is actually alienating the right of management, the right of governance of people within the scope of the contract, to the employer. And that's the thing that we have abolished in the political sphere. If you tried to organize, say, a municipality somewhere in the United States where you gave up the right to govern yourself and somebody was a little king, that would be declared unconstitutional overnight. I mean, people would allow it. But every day, that's what happens inside the firms, is people give up the right to govern themselves in an economic context, and nobody thinks twice about it. This is perfectly normal. And so you have firms run by people that are not representatives of the people they're managing. They're not delegates. They're not trustees. They are rule in their own name. The employer manages in his own name. So you have this paradox of this country, and of course the same in Europe and countries around the world, which all swear that they're ready to fight and die for democracy, and yet every day, all day long, in every firm in these countries, people give up the right to govern themselves, and nobody even wants to talk about it. And it's the same idea that here's a voluntary contract that gives up the right to govern yourself, puts you in the position of a person who is a subject, not a citizen. And the traditional name for this contract was the Pact of Subjection, where you made yourself into a subject of the sovereign, not a citizen anymore. So you gave up like your citizenship rights and so forth. And this philosopher I mentioned before, Robert Nozick, he also said we should allow people to do that. That's a libertarian thing. Libertarian, if it's a voluntary contract, nothing wrong with it. Sell yourself into slavery, give up your self-government rights, all fine. And the word democracy doesn't even appear in the index of his most famous book about all this, because democracy doesn't have a role. That you simply choose who you're going to give up your rights to. So all this is going back into the background to the employment contract, the contract to rent people, and it's the contract politically to give up the right to govern yourself in the workplace. So it's the sort of thing that we would not allow in the political sphere. Has been abolished historically, and that's what the fights were about. So it wasn't about government based on consent. It was government based upon this idea that I can give up the right to govern myself to this whoever the sovereign is, and so in the firm, it's like a little democracy, but it's not. It's private. It's not. We have this idea somehow democratic rights only apply in the public sphere and not the private sphere, and that's really a historical creation of the idea that we want. Once we got political democracy settled in the 19th century as the sort of norm in the advanced countries, then with this idea came about that well, there's a private sphere, and in the private sphere it's okay not to have democracy, and this is what happened inside the family, where the father can rule over the wife and the kids, and they don't have any rights because that's all private, so you shouldn't touch that. And so we finally seen that human rights are not parsed into only existing in the public sphere, not in a private sphere. And the same with democratic rights. So the firm, it's not part of the public sphere, it's not part of the government taking over firms or anything. These are private organizations, but they're democratic organizations in the sense that the people that work in the firm are the members, they're the citizens, they vote. They vote in the board of directors, and the board of directors chooses the management or however you want to organize the internal democracy. But so the employment contract either is an economic contract to rent yourself out, or as a political contract to give up your right to govern yourself is bogus and void on both grounds. And those contracts, in the longer term, the slavery contract and in the political sphere, the political contract to give up your rights have all been abolished. And it's what remains, but it remains as sort of the centerpiece of our system, and that's why it's so controversial, and why people don't want to talk about it, don't want to think about it. And even though they're all willing to lay down their life for democracy, they don't even seem to notice that it's giving up democracy is what happens every day in the firms, and the employer is not the representative or the delegate of the employees, and so the whole employer-employee relationship there is a non-democratic relationship. And so this website is dedicated to try to get these issues out there and get people to think about the life in which they're leading. And so you're perfecting democracy, you're perfecting private property, and then every time you try to raise the issues, people say, oh, this is communism. It's the opposite of communism. There's no state ownership involved. This is all private. It's perfecting the private property, giving people the fruits of their labor. But people don't want to talk about it because they've all been forced into this sort of dichotomous view that anything different from what we have now has got to be communism, and so try to force the issue into that kind of a straitjacket. And so we're trying to show that even historically that these are issues about democracy, these are issues about inalienable rights, these are issues about getting the fruits of your labor, all things that were not part of socialism and not part of communism at all, that don't involve government ownership or government control or anything like that. It's changing the private organizations so they become just in terms of private property, they become democratic in terms of the internal governance of the firm, and they don't put people in this position of an instrument that is employed by the employer. And so they abolish this contract that sort of gives the legal cover story to this dehumanization that goes on in the ordinary firm.